Welcome to our discussion of the Supreme Court's hearing in the healthcare decision. I'm Jeffrey Rosen, the legal affairs editor of the New Republic, and I'm joined by Jonathan Cohn, senior editor of the New Republic, and Paul Starr, professor at Princeton and TNR contributing editor. Both John and Paul were at the Supreme Court this morning in the historic arguments about the constitutionality of the mandate to buy health insurance. It was, by all accounts, a remarkable and historic discussion, and we're looking forward to hearing each of their impressions, to talking together about what we might expect in the case tomorrow, and then to taking some of your questions. So I'll begin with John. Tell us, the government, General Varelli got some very aggressive questioning from the justices. Tell us some of the highlights and what your sense was after today's remarkable argument about the fate of the healthcare mandate.
Yeah, Varelli got extremely aggressive questioning. You know, I'm a newbie to these court arguments, Jeff, so you have to back me up on how common that is. What was interesting, he definitely seemed to struggle a bit with the answers. The striking thing to me was the extent to which all of the conservatives, well, except Clarence Thomas, who said nothing, but all of the other conservatives picked up on lines that were from the conservative legal briefs and really were pressing really over and over again on the arguments which, you know, we've all heard before. You know, what is the limiting principle? If we're going to grant the government this right to make, you know, to force people to participate in the healthcare market, what can't the government force you to do? And they really seemed very caught up on this idea that, you know, by establishing this mandate, they really were forcing people to participate in a market that they might otherwise not participate in. Not all the justices were different. I think most people, and Paul, you tell me what you think. I think most of us felt that Alito and Scalia were particularly hostile on the, you know, in terms of they expressed a great deal of skepticism. With Kennedy and with Chief Justice Roberts, you know, in part based on what they said later, we'll get into this, it was a little more ambiguous. It was harder to tell, you know, how much they were actually buying into these arguments and how much they were just asking these questions aggressively.
So my impression was that, first of all, Donald Varelli.
Yes, indeed.
Donald Varelli did a terrible job in presenting the government's case. He was stumbling right out of the gate. He was inarticulate at crucial moments when he needed to come up with concise answers to questions from Justices Alito and Scalia in particular. But that the liberal justices chimed in and effectively made the arguments that Varelli was incapable of making. And so in that regard, I don't think it was decisive. I don't think, even though I thought if you were keeping score, it looked very bad in the first round, but that by the end, it was a much closer call as to what the net result of the day was.
Yes, there was a remarkable passage where Justice Breyer, seemingly frustrated with General Varelli, summed up the government's case with this exquisite concision. Do you want to give us a sense of what Breyer's case was and how that seemed to fare?
So Breyer did. Oh, go ahead, Paul.
No, you go ahead, John.
Sorry, we're not in the same room, so we're going to be after you, my dear Alphonse. No one knows who I'm asking. Let me make sure to use your names. John,
well, Jeff, let me ask you Breyer a couple times. I mean, actually, I thought Breyer did that a few times. Was there a specific? I mean, I thought in general, like Paul said, it did seem at times that basically the liberal argument was being made by the liberal justices. They had these long passages and they made different pieces. And I'm just not looking at the transcript right now. It's difficult to remember who said what. But a few of the points that they made were, well, wait a minute, isn't everybody in this market because everybody gets sick? I think Elena Kagan in particular, who was particularly sharp in her questioning, I thought, just in terms of being able to phrase things in a very pithy, quick way, making the point that, well, you know, she made the point that even the plaintiffs, the states, have acknowledged that if a government wants to, it could compel people to get insurance at the point where they show up in the emergency room and need to get care. And her point was, well, given that and given the nature of insurance, why is it suddenly unconstitutional to ask people to make those arrangements beforehand? Breyer made a number of very good arguments. I thought he was very much focused in on the idea that this was a real national problem. And if you think about it, and again, Jeff, you know more about this than I do, but the case law and the Commerce Clause is so much about federal problems versus local problems. And he kept coming back to that. I thought was an important point.
So
yes, I'm looking at the transcript now, and sorry, go ahead, Paul.
So there are a number of critical questions that came up in the oral argument. First of all, what is the market? Is it only a market for health insurance that should be considered, or is it a market for health care and health insurance together? Is health insurance, just as the government contends, a method of paying for health care? The view of Paul Clement and the opponents of the law is that the law conscripts people, forces them into the market for health insurance. The government's position is that really we're talking about one market here for health care and health insurance. People are going to enter that market for health care, and therefore there is no question here of conscripting people. People are already engaging in this economic activity. They're leaving unpaid bills. Those bills are passed on, resulting in higher insurance rates for everybody else. That affects interstate commerce. Now, there's also this crucial question of timing. With the acknowledgement by the conservatives that it would be legitimate for Congress to impose a requirement to buy insurance at the point you enter the market, at the point you have contact with a doctor or a hospital. And that's a remarkable concession, because it really just means we're talking about when it is legitimate to have that requirement. And I thought there was a very important comment by Justice Kennedy toward the end that indicated he might actually vote to uphold the mandate, in which he said that isn't the difference between the market for health insurance and the market for an automobile, for example, because the opponents said if the government can require you to buy health insurance, it can also require you to buy an automobile. But isn't the difference that even a young, healthy person is what Justice Kennedy referred to being as proximate to the healthcare market? Because even that young, healthy person may get sick at any time, may need health care, may need to enter that market. It's not like, let's say, the person who lives in Manhattan and is not going to buy a car one way or another. Even the healthy person may need that health care, may enter that market. So that's one of the various bases for distinguishing the healthcare and health insurance markets from other kinds of markets, for saying that here is a limiting principle. We're not saying the government can require people to buy any commodity, but we are saying that in this case, this is a regulation of commerce, because people do not stay out of the market for health care. Almost everybody gets in that market, and therefore it's appropriate for government to regulate.
Just to jump in, I thought that final comment from Kennedy was also quite
That's very helpful, and that surely was crucial and significant. Sorry, go ahead.
No. Your turn.
It sounds like it. Both the conservatives, Scalia and Alito, had all sorts of hypotheticals, including, could the government force you to buy burial plots, as Justice Alito said, since we're all bound to die at some point, or cell phones, as right. Chief Justice Roberts said, because that would improve the government's emergency response mechanism. And General Varelli fumbled that question, and Breyer impatiently jumped in and said, well, absolutely, if there was burials paid for by Medicaid and the burial system were essentially national and much of it were paid for by the government, then you could require burials to be bought up front, and similarly for emergency medicine. What was your sense of those exchanges, and what might the effect on Justice Kennedy have been of those kind of distinctions?
I thought that the exchange about the burial insurance was one of the points at which I really I wanted to I was waiting for Varelli to answer it in what I thought was the obvious answer, which is the one that Breyer gave, which is that yes, you could, burial insurance is one of those cases that might make sense. It is actually, when you think about it, it's not a dissimilar market. Now, that doesn't mean that it's a good idea, and it doesn't mean that the Congress would, but burial insurance does make sense. I got the impression they were so nervous about making it seem as if they were giving a blank check. They weren't willing to acknowledge that the logic they were proposing here might actually apply to a few other situations. In general, we are talking about insurance markets. I mean, in the nature of insurance is that you are paying now to protect against the possibility of something that will happen later, and that is a particular kind of market. The law recognizes that. Economists recognize that. And so it's, it's logical that, this principle would work for something like burial insurance. And amazingly to me, Varelli insists on saying, no, it's different. And it seemed to me, and Paul, you tell me if you got this impression also, one of the things that worried me, he seemed to be at various times jumping between different arguments, both legally and from a policy standpoint. And those of us who understand healthcare, who do this and follow this, know that there are really two separate arguments for the mandate, or the way it works. One of which is you have this free rider problem. Some people are going to get care and for free, and that cost will get passed on to the rest of the healthcare system. And then there's really more of an actuarial argument, which is in the sense that the insurance market cannot make a system that charges everybody the same rate, and they can't guarantee coverage for everybody with stability if there's not some way to make sure that everybody gets into the insurance market. And those are two separate policy arguments. They actually lead to two separate legal rationales, because one's more of a Commerce Clause argument, I believe. One is more about the necessary and proper clause. And it seemed to me that Varelli, in that question and in other questions, would jump from one to the other in ways that just didn't come off as very convincing.
I agree that he was very ineffective in presenting the arguments. And let me also say, by the way, that I thought his brief was not very well written. I thought Clement's brief was actually better written, more effective. It disturbed me when I read the two of them, and I think Varelli's inarticulateness confirmed that somehow effective language just deserted him, and that may have to do with a lack of clarity of thought about the whole issue. So this was definitely a matter of concern. I just want to mention here that Justice Ginsburg, at one point, brought up Social Security. And so that's a system of social insurance that originally many people said they didn't want to have. They didn't want to have to pay for their retirement. They didn't want to have to pay for unemployment insurance because they didn't expect to need it. Many people made those arguments, very similar arguments to the kinds that are made against this requirement. And then Justice Ginsburg said, isn't it odd to think, odd to suggest that it would be okay for the government to take over those insurance markets? We allow that. We've said that's constitutional. But to say that we can't have an arrangement that preserves a private insurance industry? And it really reminded you, if you weren't thinking about it, about the irony of this whole case. I mean, this is, after all, a method for achieving broader, near universal health insurance that maintains a private insurance system. This is what conservatives wanted all along. And here we see the conservative justices arguing against it. Are they, does this really flow from their deep principles, or is this just political opportunism on their part and on the part of so many others?
There's another broad question about the conservatives' sensibility that I want to ask you. Brooding over this argument was the specter of a case called Lochner. Lochner, as you know, was the case that in the progressive era struck down minimum wage and maximum hour laws, and conservatives claimed to abhor it. In fact, however, many of the healthcare challenges want to resurrect Lochner. They believe that neither the states nor the federal government could force you to buy health insurance or broccoli or gym memberships. And there was a kind of hole in the middle of the case because none of the challengers were willing to come out and say that. During the oral argument, Chief Justice Roberts emphasized the states could absolutely pass these mandates, but it's Congress that can't. And for us to pick and choose among things that Congress can do would be resurrecting Lochner. That struck me as turning Lochner on its head. The whole point of Lochner was the court striking down economic regulations in the face of contestable notions of freedom of contract. And the conservatives now seem to be poised for doing precisely that while claiming that they're doing the opposite. So I wonder your impressions of that interesting question. I'll start with John.
Sure, give me the hard question. Well, I have always thought, and Jeff, we've talked about this, that one of the, as you just said, that underneath this case that the plaintiffs are presenting, there is this idea from Lochner, and it's very much about the sort of sanctity. I call it the sort of sanctity of your wallet. The idea that you know, I think it's legally it's more defined as the contract, the sanctity of the contract, right? But I mean, it's this idea that these property rights, these contracts are sacrosanct. Which my understanding of the law, my limited, has always been that that was something that during the New Deal and when the court turned and started, you know, decided that maybe these economic regulations really were essential for the survival of capitalism in this country, that those notions kind of went out the door. You know, Lochner, my understanding of it is taught as bad law, right? I mean, in the law schools today, Lochner is thought of as you don't want to have Lochner on your side. That's one of those, if you're being accused of citing Lochner, you're in trouble. And so, as you say, you know, Clement doesn't support Lochner, and they try to avoid that. But if you read the logic of their case and you kind of strip it down, it really does come down to Lochner. It's that same idea. Because I thought what was interesting is when you ask them, you know, what I think it is easy enough. This, you know, there was this remarkable passage where Scalia said, "I think you can show that the mandate is necessary, but you cannot show that it is proper." So then the question is, all right, well, why is it not proper? You know, what, you know, because we've shown there's a compelling state interest here, right? I mean, we've shown, I mean, nobody denies that the federal government has a right to try to regulate health insurance. It's an interstate, you know, it's interstate commerce very clearly, and that they have a legitimate interest in trying to provide affordable coverage to people who cannot afford it. Nobody disputes that. So why is this not proper? And, you know, if you kind of ask yourself, what would it make it not proper? Well, it has to be this sort of Lochnerian kind of right that we've already acknowledged doesn't exist. But, you know, Clement was careful not to go there in his brief, and I was a little disappointed that, you know, the government didn't pin them down on that either.
It's true, Paul, before I ask your thoughts on this, I was struck that there was only one brief in the case that had the courage to make that candid and radical argument. It was filed by the Libertarian Institute for Justice, and they said that notions of mutuality of contract prevent the government from coercing commerce, and that principle, of course, should apply to state mandates as well as the federal one. But no one else was willing to come out and name the elephant in the room. Paul was this
actually George Will.
Yes,
Will's
yes.
column approving
He
that brief. I thought that was just extraordinary because the argument is that this mandate compels a contract. Well, it doesn't compel any particular contract. You have your choice of private insurers. But what is, I think, especially ironic, I haven't dug through George Will's old columns.
Yes.
But I wonder whether in the past he had something to say about privatization of Social Security and whether he might have been in favor of that at one time and how he could distinguish a requirement to buy a private annuity contract from a requirement to buy a health insurance contract, because it seems to me they amount to the same thing. And yet, I think Will, like many other people, have turned from calling for the privatization of Social Security to denouncing the health insurance mandate without ever recognizing that they're stepping on their own feet.
Yes, it's a fascinating irony. I haven't combed through the collected works of Will either, but as I'm under the impression that he had fervently denounced Lochnerism as judicial activism and the false consciousness that conservatives like Will and perhaps the others on the Supreme Court may be about to embrace, resurrecting Lochner while claiming to renounce it is quite wrong. Last substantive question, and then we will take some questions from our audience, and that is, before the argument started, it was a conventional wisdom was developing that it would be easy to pick off at least one conservative vote, because in the past the conservatives have embraced a relatively broad vision of the Commerce Clause. Like the two lower court judges, Lawrence Silberman and Jeff Sutton, Justice Antonin Scalia has approved Congress's ability to regulate medical marijuana despite a congressional law to the contrary. None of the conservatives, with the exception of Justice Thomas, have expressed the willingness to overturn Wickard and Filburn, the case that allowed the regulation of backyard wheat. And therefore, people thought that this might be a lopsided vote to uphold, 6-3 or 7-2. It was a very tough argument today, and already the instant commentary said it's going to be tough to pick off even one conservative. Is it your impression, does it all now come down to Kennedy, or could you still imagine that despite their tough questions, one of the other three, Roberts, Scalia, or Alito, might in fact vote to uphold the mandate under the Commerce Clause? John.
Well, again, speaking as someone, I don't know that I have a great sense of how much what we see during the courtroom arguments is a tell about how they will vote. But if I had to base it on that, honestly, I thought Roberts and Kennedy are both in play. It's not clear which way they want to go. You could make a case, I think, based on what either one of them said, that they could still uphold. I think that comment from Kennedy that Paul pointed to was potentially incredibly significant. Because that was a place for him to hang his hat if he wants to uphold this. And Roberts, I think to some extent the spin is reacting to the fact that Varelli went first, and I mean there was this sense of, I think, people of disaster after he was done, that it seemed to go so badly that a lot of people didn't notice it didn't go that well for Clement too. I mean, he held his own. I think he was the better lawyer today. But he got a lot of hard questions also, and Roberts in particular, both during that exchange and then the exchanges with the NFIB lawyer, he asked some very tough questions too, and he seemed to grasp the idea that the health insurance market was somehow different. Now, I don't know how much that indicates, but just based on that, I could see either one of them voting for it. I've heard the theory, Jeff, I'm sure you've heard this theory, that Roberts will, quote, write the majority opinion whichever way it goes. So it'll either be 5-4 to strike down and he'll write the opinion, or 6-3 to uphold and he'll write the opinion. So I could see that. And then I've actually heard one or two people say they thought Alito wasn't a lost cause. I have to say I thought he was a lost cause, but what do I know?
You're right that predictions are quite hazardous, and we shouldn't infer from the questions which way the justices will vote. But Paul, what was your impression? Is Scalia a lost cause, despite his broad vision of the Commerce Clause, and how might some of the other conservatives?
I think Scalia is a lost cause. I was not confident going in. Unlike many other people, it seemed to me to be a very close call as to how this court would rule on the mandate. And I think today didn't clarify those odds one bit. The two key votes, Kennedy and Roberts, are as uncertain at the end of the day as they were at the beginning. So my opinion is really unchanged by what happened today.
Great. Thank you very much, John and Paul, for an excellent discussion. I think we're now going to turn to one or two of our listeners' comments, and I'm going to turn it back over to Pierce.
Hello there. Can you hear me, gentlemen? I'm Pierce Stanley.
I'm not hearing anything.
Not hearing?
Yeah, I just got you. Yeah, just got your audio.
Okay, excellent. Gentlemen, thank you again for a very fascinating conversation. I'm sure these questions will linger with us for the next couple of days. But I have a couple of questions here from social media that I was hoping perhaps you could answer. I have a question from Tom Gossard from Google+, a follower of ours on the social network, who asks, I have a hunch that Chief Justice Roberts might just swing the majority in favor of the mandate. Any other elaborations on Chief Justice's role in the decision? I guess we can kick it off with Jeff.
Well, as my colleagues mentioned, it does seem that Roberts recognizes that this is going to define his Chief Justiceship, and that he will not want to be in dissent in this case. You could well see him, if he finds himself outvoted, adding a sixth vote to write the majority opinion, or if he feels strongly about this and has 5 votes to strike it down, then he could write a majority that way. My own sense, having interviewed Roberts and heard his fervent perceived desire to be a uniter rather than a divider, someone who presides over a court that produces narrow, unanimous opinions, he must surely know that after the Citizens United case, presiding over a 5-4 decision striking down health care would define his Chief Justiceship as one of the most polarizing kind. So I would have to hope that he would hesitate before choosing to write that kind of opinion, but as my colleague suggested, anything is possible in this business, so we will all wait eagerly until June.
I think we have to consider something else. The mandate is not popular. In fact, it's very unpopular. And consequently, if Roberts voted to strike it down, it's not something that most of the public would hold against him. So I think in this case, where you have a conservative majority on the court, their ideological impulses lie in the same direction as public opinion. And they do not need to fear a significant backlash if they strike down this mandate.
John, any thoughts?
Yeah, they both made a lot of sense to me.
So one final question, and it comes from Twitter. When can we expect a ruling on the Affordable Care Act? And perhaps your last opportunity on prognostication, what will it be?
I think everybody...
Well, as the moderator, I'll take the easiest... forgive me. I was just going to say that, as Paul was about to as well, everyone expects a decision by the end of the Supreme Court term, and that is usually ends in June. At the very beginning of July is the latest, so we will have a decision by late June, if not before. But beyond that, I would like to thank my colleagues for extremely thoughtful discussion. This is an experiment for the New Republic to try these sort of virtual discussions, and I think this one has been unusually provocative. So thanks to them, and I will give both of them the last word.
Well,
John, please go ahead.
Okay. Well, thank you, Jeff, actually, and a very cagey answer there at the end. I was dying to know your prediction. I guess I'll have to call you afterwards. I'm not going to make a prediction. I will say I do think there's a lot of. I think it's always good not to overreact in the heat of the moment. Just watching and listening to the coverage afterwards, I think there was a lot of people who support healthcare reform, who think the mandate is essential, ready to sort of throw their hands up in the air and think it's a lost cause. I think let's wait and see. I could see it going either way at this point. I think what Paul said before is true. You can make a very coherent argument why it will be upheld. I think you can make a coherent argument for why it won't be. I do think, and I'm going to leave this as a tease for what we'll be writing later, the interesting question is if they do strike down the mandate, what else do they strike down, and what are the effects of that? And that's something Paul has written a little bit about also, and maybe something we can discuss another day.
So I think the administration's legal strategy is bizarre and inexplicable. I think yesterday they should have been arguing for the application of the Anti-Injunction Act. It was seemingly contradictory to say it wasn't a tax yesterday and to say it came under the taxing power today. I think they would have had a stronger argument today on the taxing power if they had held it yesterday that it was a tax. I think also tomorrow they're going to be arguing that the mandate is inseparable from the provisions for community rating and guaranteed issue. And again, I find that a completely bizarre position for the administration to take. I understand why they're doing it, but it seems to me totally unnecessary and potentially disastrous. The 11th Circuit only struck down the mandate. It left the rest of the law standing. It would be a problem, certainly, if this court strikes down the mandate. But it could leave it to Congress to decide how to remedy that situation, and that is really what it should do. And the administration should take that view tomorrow. It would not be the disastrous result if the court strikes down both the mandate. Would not be as disastrous as if it would be if the court strikes down both the mandate and those other provisions. So that's, I'm really puzzled by the administration's position. I think the brief they filed on the mandate was a very badly written one. I think Varelli's presentation was dreadful today. All in all, I think we should be looking for the administration to replace the Solicitor General and get somebody there who can defend its position in court.
On that cheerful note, thank you for an excellent discussion, and we'll look forward to continuing this before long. And thanks to all of you for watching.
Thank you.